Hello, our lovely viewers and listeners. Welcome to another exciting yet informative episode of the BPA Community First podcast, where we have legal and social conversations with the community. So, today we are going to discuss a crucial yet delicate business structure in Ghana. This business structure is close to the hearts of many families in Ghana: family businesses or family owned businesses. These businesses form a substantial portion of Ghana's economic landscape, and they are established with the hopes that they will remain in the family for generations to come. However, according to statistics, less than 30% of these businesses are able to transcend the third generation. This is because the reality is more complex. Death, marriages, divorces, succession, both legal and cultural, all introduce new dynamics that may shift ownership outside of the family. In this episode, we intend to unpack these realities. And joining me to unpack these realities are Tracy Ikia Ansa Ofusu, a legal associate with the Business Support Services team of BNP Associates, and our partner, Michelle Nanaya Isuman.
Hi, Ajwa.
Hi, Michelle. Hi, Tracy.
Hi,
It's a
Adjo.
pleasure having both of you on here.
It's a pleasure to be here.
It's a pleasure.
So let's start from the basics before we go into the legal complexities of family businesses. When we say family businesses or family owned businesses in the Ghanaian setting, what do we mean?
I think the general understanding or the general definition that could be given to a family owned business are businesses that are owned and controlled by a family. So it can, in some generally, but there might be some circumstances in which the management or management roles are also played by members of the family. Now, in Ghana, the family business is actually very fundamental to our economic and entrepreneurial space. About 80% of businesses in Ghana, according to the Association of Ghanaian Industries, are run or are family owned businesses. So it shows that in Ghana, it's actually an active part of our business environment.
Yes, so I think Tracy has said it all. What I will just add to it is just the clarity that with specifically when we talk about companies limited by shares, it's important to come from the perspective that family-owned businesses are shareholders who are family and not just directors. You can have a scenario where the shareholders or family members are directors as well, but that's not always the case. There are also instances where it's just the shareholder. And pivoting from that, when we say businesses, it covers a broad range of vehicles. So you have the sole proprietorship, you have partnership, and at least in Ghana, you have partnership, and you have companies under the Companies Act, even trusts are sometimes used as vehicles. But ultimately, I think for the purpose of this discussion, we are going to be looking at companies limited by shares, right? Because that is where we consider issues of perpetuity and all that, as opposed to a sole proprietorship, where the business dies with the individual.
So, given that most of the businesses that we have in Ghana are family owned businesses, then that would mean that most of these businesses have a lot of advantages. There are a lot of things that go into the success of these businesses. So when we look at family owned businesses, what kind of advantages can we easily identify with family businesses?
Okay, what comes to my mind immediately is raising funds. One thing a lot of businesses struggle with is raising funds externally. When it comes to family-owned businesses, I'm not saying it's necessarily easier, but when the people you are seeking the funding for, in either to set up the business and later incorporate and then issue shares with, are people that you are either married to, which can be that type of family business, or a family business that includes members of your extended family, like your cousins, your brothers, with that one, I know where you live. I know your mom. Like, I can always get someone to get you to pay up when the need arises. So it's a little easier raising funds in the context of a family business. Another advantages that comes out to me is the fact that a lot of family-owned businesses in Ghana are built in industries or sectors that the family or members of the family have prior experience in. When we look at the more informal sector, we see that in our markets, those who sell fabrics, a lot of the time when you ask their grandmothers, their mothers were already involved in these businesses. They involved their daughters or sons, and that is how, in essence, the family-owned business came up. So they take advantage of these experiences, these lessons, these connections, and they can use that to pivot to build one bigger, sustainable body. So I think that is, for me, the major advantage of family business.
Yes, and when we talk about family-owned businesses, one of the advantages that just jump at me is the fact that we have common values. We are bound by blood, so we decide that we come up with something that is going to benefit us in the long run. So due to our shared values, we have a lot of motivation, or it's an incentive for us to make sure that we put in our all so that the generations to come can also rely on something. However,
I'm laughing because it looks like we are going to the sad side of the story, the disadvantages.
Yes. However, it is not all rosy. And to be very honest, that is the reason why most family businesses do not even transcend the third generation. So while they look attractive and while they are prevalent in our societies, they have very, very daunting disadvantages as well. And would like to talk about some of these disadvantages.
Okay, so coming from Tracy's first advantage, that could also work as a disadvantage because when you are a family and you come together to set up a business, you take ownership of it and it's more personal, it's more emotional and relational. So some families may find it difficult exploring strategic commercial options, which may be advantageous to the business when it comes to raising funds. So in a family business, I reckon that it's going to be that much harder to convince them, especially if you have the scenario where the private equity company, the fund is coming in the form of equity. So you are bound to face some resistance on that front. So that's one disadvantage or advantage, depending on how you look at it. Now, another thing is about governance. Because of the familiarity, you sometimes have the scenario where families struggle to comply. It's three cousins. We have our business. We see each other every day. Over the weekend, our kids play. Why must we come and sit down and have an AGM with how many days notice, so formal and strict? If we're directors of the company, that means that we're meeting twice a year to formally discuss things, complying with governance issues. That could sometimes be an issue. And in this changing global era where we're more strict on compliance, we're coming to a place where it's taken more seriously if your business wants to grow. And so it could be a big challenge to the company. Also about accountability, I guess. That could also be an issue. So,
well, to add up to what Michelle just said, I think another big issue is for family businesses that prefer to have family members involved in management. There's sometimes the tendency to put members of the family who might not necessarily be qualified for those sensitive roles at sensitive positions, because the idea is, well, it's my
It's a
family.
family.
So why
It's a
isn't a
business.
member of my family maybe the head of this department or the CEO or those type of situations?
Let's keep it in the family.
Yes, and then it leads to a little bit of poor
Conflict.
management, because obviously the more qualified the person is, the better they can run
Yeah.
the entire show. So,
And there are lots of emotions that come to play as well. People would not be able to distinguish between the business and their emotions. So if I'm fighting with, let's say, the director, you call us for a meeting, I'm not going to show.
So it gets personal.
Yes.
I was coming to comment on your earlier point about qualification and about how that could be an issue. Do you think that the family wanting to keep trade secrets in could also account for some of the reasons? Because depending on the nature of the business, there may be a certain trick that they've hacked that they kind of want to keep within the club. So
I'm sure in some context, depending on the rules, those rules are so in line with your trade secrets that you might not necessarily want a qualified but stranger sitting in those roles. But I think generally, a lot of family businesses that want to thrive should have the understanding that where there's not that element of secrecy or exposure to trade secrets, they should be a bit more open to either ensuring that the members of the family they bring on have the requisite qualification, or they actually get outsiders who have the qualifications to help them run the business and get it to the highest possible point it can get to.
Yes, and there are certain industries that require people to have a certain qualification to occupy management positions and directorships. So, for instance, the insurance industry, the finance industry. So, there's a fit and proper person requirement. So, I think that the solution to that is, if that comes very close to home, then make sure you train people, or you make sure that the people in your family get those qualifications that allows them to occupy these positions while remaining compliant to the legal or the regulatory requirements. Are there specific provisions in the Companies Act, for example, that anticipates this business model, looking at how many businesses we have in Ghana that are family owned?
So I'd say that no, there's no specific provision that, outrightly says for family businesses, this is what you must do. But in the Companies Act, there are certain measures and provisions that can be used to your advantage as a family business, and particularly Section 98, which talks about the fact that the company can, in its constitution, expressly provide for restriction on transfer of shares. And when it comes to that, it means that you can put in your constitution that shares should only be transferred to family members. And then you'd have to be very, very, very careful about how you define who a family member is. So that's one avenue. And you also need to bear in mind that as we have 80% already being family-owned businesses, under the assumption that most of them are incorporated as company limited by shares, it means that a lot of people have already issued shares. And that provision further provides that where that is introduced into the constitution after the fact, after shares have been issued, it means that the existing shareholder will have to consent to the transfer with those additional restrictions. So, and it must be in writing, of course. So that's one thing that can be explored. And then also within the shareholders agreement, sometimes it's not expressly provided in the Companies Act as something that can be explored. But within your shareholders agreement, you can sometimes provide for trigger clauses for preemption rights and forced transfers. So if you have transmission, for instance, of shares, the death of a shareholder can trigger, it can be one of the reasons that you place for triggering the forced transfer and the preemption rights, allowing other family members to buy the shares.
Yes,
Tracy,
just to sort of clarify what Michelle said, preemptory rights, for those that don't know, they are basically the rights for existing shareholders to have like the first bid or first offer when a shareholder wants to sell their shares. So it's like within the company, existing shareholders, you get first offer. If all of you decline, and then I can go outside the company and offer or transfer my shares to outside it. So with that, it's like I've given opportunity to the members of the family, if they can, to buy these shares from me, and now our family business remains family business. So that's just some clarity on that.
what do you think of trust as well?
Well, I think trusts are also a very useful vehicle in this context, in the sense that they enable the shares themselves, which are what enables a family member benefits from the proceeds or income of the family, to be held by someone independent of these family members, such that when the incidents you mentioned, which can cause issues with the dilution of family businesses, be it marriage, divorces, death, here the shares were not owned by these family members in their personal capacity, just that these family members were provided for in the trust deed as people who should benefit from any revenue or income from the trust which is holding these shares. So trust are also a very necessary and useful tool when it comes to managing family businesses and utilizing it.
Great. So now let's talk about the elephant in the room, succession and continuity. So what is this issue, or what generally affects the ability of these family-owned businesses to transcend the third generation? Because I realized that usually for the first generation, we had $10,000 and a dream that we're going to set up this
Why
business.
not this?
Yes. Well, let's say cities. Yes. So we're not getting in trouble with the BOG. Yes. And we decided that we're going to set up this business. We had a gentleman's agreement that, well, Tracy passes on to her children. We are going to ensure that this thing remains in there. And then there comes the second generation, the third generation. And then continuity is greatly challenged, or it's threatened. What do we think are some of the factors that affect the continuity of some of these family-owned businesses?
So I think continuity, succession, and in the context of continuity, has two phases. So it can be in the context of where family is management, and in the context of ownership. So when family is management, I think one big deal, and we see it a lot, is like we don't like to let go. So we don't have a clear plan that if maybe the main members of the family, those who started the first generation, occupy roles like managing director, CEO, all that, there's a clear line as to who is next in line to take over when the unfortunate happens. Either they retire or they die, or for some reason they are incapacitated. So for a long time, these individuals were the face of the company. Though it's incorporated in this context, they were the ones who had all the useful relationships. They were the face of the company. They did business. So the absence of a clear succession line and understanding among all members that this person occupying this role, when he's not there, maybe it's this son or this daughter or this cousin. When the unfortunate happens, now there's a huge power gap that needs to be filled. Then unfortunately, when power comes into play, there can be confusion. Why this person or not me? So that is a big issue when it comes to succession in the management context. Now, when it comes to succession in the ownership context, I think a big deal is what provisions, especially when the shares, which are your claim to ownership, were your personal property and not kept in a trust. How did you leave your family upon your death? Did you die with a will or testate, as we like to call it in the law, or did you die intestate? Because when you die intestate, you have made it very clear as to who should benefit from these shares. So with that one, if you are someone who truly believed in the values of the family business, obviously you would give it to someone. Okay, no, let me not say obvious.
You're hoping.
Yes.
I'm hoping that you would give it to someone who you knew would comply with whatever agreement, gentleman's agreement or otherwise, that the family had.
That poses a lot of trust in people, you know, and some of these things, I mean, it's not planned. So even for instance, if shares are in Kofi Menu's name and he does his will and the will is not even well drafted, the shares could even fall in the residual clause. And that's a big danger because what if his girlfriend is the beneficiary of the residual clause? Then you have a side chick in your company
Yes,
with the main wife.
She's the new CEO, please. She is the new CEO.
You know, and another danger is where you even have a shareholders agreement that gives the person certain rights, you know, to nominate directors, all those kind of things. Let's say you had already started putting things in place, but you've not really put in the right structures and all that, and the person dies, and then now his side chick steps into his shoes and she has the right to nominate someone to the board and has all these rights in the shareholders agreement. It promises to be exciting.
Very exciting.
And can we complicate this a bit? We know in Ghana, when it comes to inheritance, we have two main mechanisms. So we have the matrilineal and patrilineal. I mean, we might think that these things are fading out, but there are people that still believe in it. So my nephew inherits from me. My children are probably disinherited, for the lack of a better word. When we have these mechanisms in place, how do we merge this? How do we marry this with family business without causing problems? Like, I mean, in the generations to come, how do we ensure that the family stays in? Sorry, the shares stay in the family, or sorry, the shares stay in the family on the, I don't know how to say it.
Depending on your mode of inheritance.
Yes,
if you have a very
mode of
traditional
inheritance. And do you even think that we still have that properly so called, and the laws do not necessarily permit these things from happening in today's society?
So I think again that it comes down to, for instance, if you do the amendment of your constitution, what do you define as family? Even in your trust deed, if you say the trust is holding the shares, who are those defined as beneficiaries? What's the criteria? And you may even have a further issue which may complicate matters, is the requirements to disclose your beneficial owners.
Exactly.
So if you are not particular about, it's not as simple as we're saying it.
Yeah.
You really have to go into the nitty-gritties to make sure that if that is what you hope to have, a patrilineal inheritance, and that's what you call family, it has to be reflected that way. If you say, okay, we are Ashantis who have come together, we're setting up our business, Ashantis inherit matrilineally, and we want it to be family, that means that the sons have to understand that at the end of this, I may be holding the shares, but at the end of this, it's not for me. I cannot give it to my children.
No.
After me, that's it. So all those things have to be clear, painfully clear in the constitution or in your trust deed, depending on how you explore your options.
I think another thing that a lot of people don't realize is intestacy also can put a wrench in your well-crafted family business succession plan. With a will, at least you have the power to determine who gets what. But here's a case where Ghana, we have the intestate succession law, which governs the distribution of assets for someone who unfortunately either died without a will or for whatever reason your will was held to be invalid. Now, the law has given certain distribution fractions or ratios, which the wife has her portion, her children are entitled, surviving parents, and then it comes to the extended family and who the person's customary law, be it matrilineal or patrilineal, is recognized as family. So, as much as possible, and when you come to lawyers, it's like we are always preaching the gospel of wills. But wills and documentation and formalities create certainty. And for anything that you want to have some amount of continuity, certainty is always best. So when you want to have excellent succession, as I said, be it management or be it in ownership, there should be some element of laying down the plans in place for when these eventualities do happen.
Sorry, this is not legal advice, please. If you want legal advice, you have to come and hire us.
Yes.
This is not an advert as well. Just a disclaimer.
Okay, so that's exciting. And how about divorces? What happens in the case of a divorce where we set up the business as husband and wife and we are estranged now and I want a portion of it? Can you say that even though we set it up together, I have put in restrictions? So you, the wife, for example, you cannot transfer it to anybody else apart from, say, my children, if we inherit patrilineally, for instance. Can you say that even though you worked hard and you participated and you were actively involved in the setting up of the business while we are exchanged, I can determine or I can restrict your rights to even transfer?
So
That's one part. I'm sorry, that's one part. And the second part is we got married and we set up the business during the subsistence of the marriage. Can I lay claims to your shares generally?
Wow. So let me address the first issues, which is when two people are married, fortunately, there's been an estrangement, and you put it in your share transfer document that the only people who the wife, can transfer the shares to are the children of that marriage. So I think I'll give a little bit of context in relation to how matrimonial property is distributed in Ghana. So in Ghana, for someone to be able to lay claim to property within the context of marriage or divorce, the court looks at one major thing, which was when this property was acquired. So if the property was acquired prior to the existence of the marriage, then unfortunately, this spouse, within the context of distribution of matrimonial property, does not come in. But when the property was acquired during the subsistence of the marriage, then the court presumes or assumes that the other party, even in the event where their name for whatever reason was not provided for on the share certificates or in the register of shares as a shareholder, until evidence is brought to contradict that this person did not contribute to setting up of this business, the court assumes that you did contribute and it will distribute it in an equitable manner. Now, in the event that, as we said, this woman has, or let's assume that she is a shareholder and she was married to you, but upon quick thinking, upon coming to consult BNP Associates Business Support Services, we advised you while everything was rosy and beautiful that it's because your goal is to keep a family business within all of you's understanding of the family. Why don't you insert a clause restricting the transfer of shares to only this class of people? So people who were born of Mr. and Mrs. A, we make it very clear, well defined. Then unfortunately, in the event that the marriage of Mr. and Mrs. A has fallen apart, Mrs. A is still bound by the provisions of the registered constitution, which she consented to. So she's limited as to who she can transfer these shares to. Now, in the second scenario where Mr. A built a business with his wife. But unfortunately for him, or unfortunately for her, she wasn't registered as a shareholder. And Mr. A is insisting that, well, we are getting divorced. Your name is not on the share register. On what basis are you claiming rights or interest in this property? Then the court will now look at it in the sense that this business was set up, incorporated. Your shares were acquired while you guys were married. So now the presumption is she may have contributed to it. And if she can provide some form of evidence to support the presumption the court has in her favor, then it now comes down to, even though it's in your interest or it was your wish that it would stay within the company, she really does have some rights to the shares in that company. Now, one thing we like to bear in mind is that even though there's a general presumption that property acquired during the subsistence of the marriage is matrimonial property, there are certain exceptions. So when it's a gift, so for example, if you acquire the shares in the company through gifts, through inheritance, and our favorite structure, through a trust, unfortunately, the court tends to exclude such property as subject to matrimonial property distribution.
So that means that like a second generation shareholder who inherited the shares as a family member,
his shares will not be considered
exactly
as matrimonial property during the divorce.
Okay.
So sorry for the divorce.
And Michelle, you mentioned trusts. Can you tell us, can you give a very brief explanation of what you mean by families contemplating setting up a trust as a vehicle to protect the sanctity of their family business?
Okay, so I always say that our laws in Ghana are not too well defined when it comes to trust. But we have the common law system of trust, which creates a fiduciary relationship. So you have the trustees who hold legal title to an asset. Then you have the settlor, and then you have the beneficiaries. So and the underlying document for that is your trust deed, which details the rights, duties, obligations of all the parties. There are different forms of trust. There's the express trust, different forms of trust. But ultimately, your trust deed has to govern the relationship. Now, what we envisage by what Tracy was even saying is that you would use the trust deed to kind of set up the trust, and then legal title to the shares would be transferred to the trustees in trust for the beneficiaries, who are family members, who are defined properly in the trust deed. So essentially, it's not the family members that are all. So maybe Kofi Menu is holding 10 shares. Kwabna is holding 5 shares. No, you have the trusts holding the shares, and then you have the beneficiaries under the trust who are enjoying proceeds. If dividends are paid, they are handed over. The trustees then share it according to the trust deed to the beneficiaries. So that's
to top up to what Michelle said. One good thing about trust is that in the long run, when your family expands, when the people who can qualify to be shareholders increase, it creates a situation whereby you don't now have to feel like, oh, I only got 10 shares, I only got 20 shares. The trust deed has provided for anybody who fits the criteria of shareholder to benefit. So you don't have to worry about how many shares this person is getting. All you need to know is I'm a beneficiary, a member of this family, I fall into this class. And however the trust deed define your benefits among the dividend, be it 10%, 20%, whatever, you're going to be entitled to that.
Amazing. So, trusts are a very solid way to protect the family character of a business, and
they are
also
one
the
way.
yes, yes, and to ensure longevity.
Yes, that is one way.
Yeah. Yes. So,
but I think I need to add that depending on the sector of your business, you may not want to use a trust vehicle because yes, shares are limited liability shares. So the liability of the shareholder is limited to whatever is not paid
Yeah.
as the shares. But when it comes to trust, there's a potential for the veil to be pierced and for the trustee to be personally liable. So, by extension, the unpaid liability of the shares may become the
burden.
direct issue of the trustee. I don't know if
Yes.
What's the
what
trustees
I'm
company?
saying. Pardon me?
What's the trustees a company?
Yes, but still exposure.
Yeah.
Even if it's a company you've appointed. So that's what I'm saying. It's you have to weigh the risks on all sides and make a decision of what's good for you. And I think when we advise you
You will be able to-
formally
we'll consider
based
all
on your
that.
you will look at your
And we'll look at
context.
the fact that maybe for you, trust might not be the
Yeah.
best.
Yeah. So finally, what key takeaways would you want family businesses to remember from this discussion?
I think that they should go away with the fact that structuring is very important. That even I think no one sets up a business for it to end at the first generation. The hope is your descendants, 3, 4 generation will look back and say, this is something my grandmother or great grandmother built. But in order to give your business a fighting chance, you need to put in place the structures. We've talked a lot about incorporating. It's very important. Governance, also very important. And that's Michelle's strong point. Yes. It's something that she hammers on a lot about the quality of your corporate governance is as important as the direct management positions, when the people occupy those positions. So I think family should come away with, just because it's a family business does not mean it should be poorly structured and not necessarily have the clarity and defined rules that any other business between people who are strangers should have.
I mean, my key takeaway is if you want your business to last, see your lawyers. See your lawyers. Speak to them. They will help you. Yes.
Speak to your lawyers. So I'd like to hand over to Michelle to give us a practical scenario of what might likely happen to the shares of a couple that's going through a divorce.
Thank you, Ajwa, for the opportunity for us to discuss the dilemmas of some people. So let me just give the scenario and then we can discuss. So the Sam family is a prominent entrepreneurial family in Ghana. Over the decades, they've built a diverse portfolio of businesses, all held under their umbrella company, Sam Industries Limited, a family-owned holding company. As part of their tradition, each member of the Sam family receives an allotment of shares in Sam Industries upon reaching the ripe old age of 28. On his 28th birthday, Kwame Sam, a younger son of the family, was gifted 500 shares by his parents. Kwame married Helen at the age of 26. 3 years after receiving his shares, marital tensions escalated, leading to divorce proceedings. The family is concerned that Helen, as Kwame's spouse, might claim entitlement to a portion of his shares during divorce settlement proceedings. They fear that this could lead to a situation whereby a non-family member becomes a shareholder in some industries, potentially disrupting the tightly held family ownership structure. What should they do?
Wow. This is
This is interesting.
very
The Sams
interesting.
are in trouble. Yeah.
So I think it's very clear that in this case, Kwame Sam acquired his shares while married to Helen. And as I just explained, well, it's clear the shares are potentially subject to matrimony, as they are considered as matrimonial property because they were acquired during the subsequence of the marriage. However, the beautiful thing about this scenario is that Kwame Sam got them as a result of a gift. So luckily for the Sam family and Sam Industries, this falls within the exceptions to matrimonial property. And as such, within this context, Helen cannot, unfortunately, claim it as part of the matrimonial property.
I want to
So
put a
what's the-
spin on it. You know, the Companies Act talks about the fact that shares should be issued for consideration.
Mhm.
Can the company
Mhm.
decide to gift shares?
Based on love and affection. The consideration of love and affection.
Well, the company's access shares should be issued for consideration, true. And in this context, if you mentioned that can it be issued for free? Free is not consideration. Free is not consideration. So in such a situation, I think presuming this situation, maybe Kwame Sam's parents were the ones who transferred it to him.
Yes,
So that's the safeguard.
that would
But
be
in
it.
another context, I think what will have to be the case is in Ghana, shares are what we call no par value, meaning the value of the shares is assigned by the company. So they would usually maybe, even though it's a gift, in order to comply with the provisions of the Companies Act, put some nominal value on the shares to allow Kwame Sam to be comfortably able to provide consideration and claim his gift rightfully under the law.
So if that happens, is it still a gift? And can he still say, I was gifted those shares?
Well, in that situation, we've entered the realm of did Helen, now that it has changed the color in some form of declare gifts to something that you provided consideration for. It has changed the color and it's taking it into a more commercial situation. So here it's going to be matrimonial property open to the assumption or presumption that Helen did provide some contribution to Kwame's ability to acquire those shares. So it is now up to Kwame to provide evidence to what we lawyers like to say rebut or to set aside this assumption that indeed both of them collaborated to acquire this property and he acquired it by his own personal means and ways.
So that means that your answer to the question as a lawyer is it depends.
It depends. It depends.
Always depends.
Yes. I associate myself with Tracy's comments and I have nothing further to add to this. Yes.
But what about settlements under Section
The
20?
financial settlement.
Yes, under Section 20.
So when it comes to financial settlement, the court has a wide discretion to settle financially the personal property of a spouse the spouse who is supposed to settle the other spouse. So they have the right to settle their personal properties on the other spouse.
So do you think the first thing the court will have to look at is, first of all, is it his personal property?
Yeah.
And then
Yes.
beyond his personal property, do you think Ghanaian courts are ready for that conversation of shares being family shares, as opposed
don't-
kind of like how in land
Family land.
there's
and
family land and
then
you know
there's
you
individual
can't.
land.
Yeah.
Do you think we are ready for that kind of conversation?
So
So I think in this context, the safest way to argue that shares are family shares is, what does your constitution say? Because even if the shares, for whatever reason, by some coincidence, were all acquired by members of the family in this company, it's not enough to convince the court why this outsider, who was once part of your family by virtue of marriage, cannot walk away with some element of the family. You can walk away with your children.
you snooze, you lose.
But here's a case where your constitution is clear. And the constitution is the governing document, the spirit. Let me go into the spirit of the company. So it is from the constitution that the court will be able to deduce that when this company was set up, it was meant to benefit this group of people. It was meant to be owned by this group of people. So in such context, where you have a constitution that clearly states shares can only be transferred to this set of people, to this group of people. And unfortunately, the situation is such that, unlike other people who had trust, your shares were given to you as your personal property in your name. So it is now your personal property. The power of the court to exercise its discretion to settle property on your spouse will be exercised by our judges in fairness and in understanding of like the state we live in, such that it is financial provision. It can be money, it can be movable and immovable property. So bearing in mind that of all the property this man has, is it truly these
I
shares
probably do
that
not have money to settle. So
But you have shares of your family.
yes, I have shares of my family.
well,
so
then the question will be that if she's coming forward with this, maybe the court could offer that, would you be able to gather some money to give her in exchange for these shares? But I think our courts are evolving. And even though we've not seen to our knowledge incidences involving such a situation, courts do recognize shares as personal property and they can be subject to
Sure.
distribution during a
Exactly.
divorce.
Yeah.
Exactly. So thank you so much for joining us today, and a big thank you to my fun yet very, very, very intelligent and very, very resourceful colleagues, Tracy and partner Michelle, for joining us to dissect this crucial but delicate subject. We've learned that family businesses are, although they are seated in love, legacy, and survival, survival often depends on clear structures, legal safeguards, and sometimes having very difficult but necessary conversations. So to our listeners, if you are part of a family business, this might be the time to have these conversations and see your lawyers and to give you the best advice on the best approach to protect your families. My name is Ajwa Usuminta, and I was your host for this discussion. And until next time, stay informed and keep building legacies that last.